You are listening to PR Radio Station of America.
In Washington, the offices of the Department of Homeland Security buzzed with quiet urgency. Acting IC Director Todd Lyons signed a series of letters on September 10th, each carrying a message sharp enough to start a storm. These letters were not routine. They were warnings aimed at three of the largest states in the nation: California, New York, and Illinois. Inside each envelope was a demand for compliance, a demand that state leaders honor thousands of immigration detainers lodged against individuals in custody. The letters gave only 2 days for an answer, setting the tone for confrontation. An immigration detainer is a federal request for local jails to hold a person beyond their scheduled release, usually for up to 48 hours, so immigration officers can arrive to take custody. To federal officials, these detainers are essential tools to prevent undocumented migrants with criminal charges from re-entering communities. To many states, however, they represent legal and constitutional risks. The letters carried both legal language and political weight, telling state attorneys general to either comply or face consequences. They were more than paper. They were battle lines drawn in ink. The first responses set the stage. New York and Illinois sent formal replies that same week. Both said detainers were requests, not binding orders, and they would not change their state policies. California, however, stayed silent. Its Attorney General's office did not immediately respond, leaving Lyons to interpret silence as refusal. That silence would soon be treated as defiance. Within days, he issued another round of letters, this time sharper in tone. He accused the states of obstructing federal immigration enforcement and warned of legal action through the Department of Justice. Lyons' follow-up letters went beyond warnings. They hinted at lawsuits, funding cuts, and direct intervention from federal agencies. In his message to Illinois Attorney General Kwame Raoul, Lyons wrote that refusal to honor detainers would result in thousands of criminal aliens being released into Illinois communities. New York Attorney General Letitia James received similar words. In California, Attorney General Rob Bonta was told that his silence would be treated as ongoing refusal. The message was clear: comply or be dragged into federal court. As the letters circulated, political offices and media outlets caught wind of the looming battle. Sanctuary states saw the warnings as federal overreach. Federal officials portrayed them as necessary measures to protect public safety. The letters were no longer confined to attorney generals' desks. They became public symbols of a standoff between states and Washington, touching off debates that stretched from courtrooms to living rooms. What began as correspondence was about to ignite a firestorm that would dominate headlines and reshape the conversation about immigration enforcement. In Sacramento, after days of pressure, the California Attorney General's office released a carefully worded letter. It reminded federal officials of past court rulings. Detainers were legally requests, not commands. The letter cited federal regulations and previous cases in which judges had ruled that holding individuals without warrants violated constitutional protections. California law already limited cooperation, allowing local police to honor detainers only in cases of serious convictions. By staying consistent, the state signaled that it would not bend to Washington's demands. In Chicago, Illinois Attorney General Kwame Raoul's office pointed back to its earlier letter sent on September 12th. The message was unambiguous. Illinois could not force local police to honor IC requests without judicial warrants. The state rarely received detainers directly, it said, because the Attorney General's office did not manage pretrial detention. Forcing compliance would not only break state law, but also expose police to lawsuits if IC made mistakes. Raoul's letter underlined a key concern. Mistaken detentions were not rare. They were growing, and Illinois would not risk liability to follow federal orders it considered voluntary. In Albany, New York Attorney General Letitia James also stood firm. State law required judicial warrants for cooperation with immigration officers. Administrative detainers signed only by federal officials were not enough. The Attorney General's office reminded Lyons that New York had passed its restrictions to protect local communities and ensure constitutional rights. 2 aides to Governor Kathy Hochul confirmed that the state would not expand cooperation beyond its current policies. The refusal was framed not as rebellion, but as defense of state sovereignty and legal responsibility. Across all three states, a common theme emerged: liability. Local and state authorities argued that responding to detainers without warrants opened the door to lawsuits. If ICE targeted the wrong person, states and cities could be held accountable for unlawful detention. Illinois went further, stating bluntly that ICE errors were growing at an alarming pace. For state attorneys, the issue was not only about federal versus state power. It was about protecting local law enforcement from costly and damaging mistakes that could undermine trust in the justice system. By the end of the week, the picture was clear. California, Illinois, and New York had refused to comply. Their letters framed detainers as optional. Their laws shielded local authorities from federal influence, and their courts backed their positions. What federal officials saw as obstruction, state leaders saw as defense of constitutional rights and community trust. The stage was now set for the next escalation. Washington had threatened lawsuits and funding cuts. The states had drawn a line of defiance. The clash was no longer about paperwork, but about the limits of federal power. In Washington, officials at the Department of Homeland Security wasted no time striking back. Assistant Secretary Tricia McLaughlin issued a statement blasting sanctuary states. She accused California, New York, and Illinois of putting politics over safety. She warned that their refusal to honor detainers would lead to violent offenders walking free. Her words painted a picture of communities at risk, saying that sanctuary policies combined with cashless bail were a recipe for disaster. It was a message designed not only for state officials, but also for the public, hoping to turn opinion against sanctuary laws. To strengthen their case, DHS released arrest statistics. Since the start of the Trump administration, immigration officers had arrested roughly 400,000 undocumented migrants. Officials said that 70% of those arrested faced criminal charges or had prior convictions. They listed crimes including sex offenses against minors, assaults on police officers with weapons, drug trafficking, and firearms charges. These examples were presented as proof that states refusing detainers were releasing dangerous individuals back into communities. Supporters of the administration echoed these claims, saying the states were shielding criminals. Federal officials also highlighted the practical consequences of state refusal. If jails and prisons refused to honor detainers, ICE agents would be forced to conduct more arrests in public. This meant officers showing up in neighborhoods, workplaces, and homes. These operations were riskier for both law enforcement and the public. Already, similar raids in New York City, Chicago, and Los Angeles had led to tense confrontations and arrests. Protests often followed, with activists accusing federal agents of terrorizing communities. DHS argued the states were making the situation worse, forcing immigration enforcement onto city streets. Behind the fiery rhetoric, the administration prepared concrete action. Senior officials confirmed that the Department of Justice would be enlisted to file lawsuits against the non-compliant states. They also discussed cutting off federal grants that funded local law enforcement programs, schools, and other services. The threat of losing millions of dollars in federal aid was meant to pressure states into compliance. Federal leaders framed the issue as a test of national authority, saying they could not allow what they described as obstruction to continue unchecked. By mid-September, the confrontation had escalated far beyond letters. On one side was the Trump administration, presenting itself as the guardian of national security. On the other side were state leaders defending their laws, insisting they were protecting constitutional rights and community trust. Both sides claimed to be safeguarding public safety, yet their visions of security could not be more different. The federal response marked a turning point. Lawsuits, funding battles, and public clashes were no longer distant possibilities. They were now inevitable. In federal courtrooms across the nation, the question of detainers had already been tested. Judges had ruled repeatedly that states could not be compelled to hold individuals without warrants issued by a judge. Detainers signed only by immigration officers carried less legal weight. States such as California, New York, and Illinois leaned on these rulings, citing the Fourth Amendment's protection against unlawful detention. Legal scholars pointed out that forcing states to comply would spark constitutional challenges and might unravel the balance of state and federal authority. The courtroom was becoming as important as the streets in this fight. Each state had passed its own version of sanctuary protections. California law barred police from honoring detainers except in cases involving serious crimes. New York required judicial warrants before cooperating with immigration officers. Illinois enacted the Trust Act, which flatly prohibited detention without a judge's order. Supporters of these laws argued they built trust between local police and immigrant communities. Without them, many residents would fear reporting crimes or cooperating with investigators, weakening public safety overall. Sanctuary laws, in their view, were not shields for criminals, but safeguards for democracy and fairness. The Trump administration framed sanctuary states as reckless and irresponsible. Their messaging focused on dramatic stories of violent crimes committed by undocumented migrants who had been released instead of transferred to immigration officers. Meanwhile, governors and attorneys general framed their resistance as defense of liberty and community trust. In press conferences, they insisted that Washington was trampling on state authority and ignoring constitutional limits. Each side crafted its narrative not only for legal battles, but also for public opinion, knowing that voters were watching closely. The threat to cut federal funding raised the stakes even higher. Grants to police departments, schools, and local governments often provided crucial resources. State officials argued that punishing entire communities over legal disagreements was unfair and harmful. Yet federal leaders insisted the cuts were leverage needed to force compliance. The fight over money revealed the raw power struggle at the heart of the issue. Washington had the purse strings, but states had their own laws and courts backing them. Neither side seemed willing to back down. By this stage, observers realized the standoff was about more than detainers. It was a proxy war over the balance of power in America. Could federal officials force states to carry out their policies, or did states have the right to resist in the name of local governance and constitutional protections? The answer would shape not only immigration enforcement, but also the future of federalism. Lawyers, activists, and politicians all understood that whatever happened in this fight could ripple far beyond sanctuary states, setting precedents that would echo for decades. In cities like New York, Chicago, and Los Angeles, the tension quickly left the courtrooms and spilled into the streets. Protesters gathered outside immigration facilities and federal buildings, carrying signs that read "Sanctuary for All" and chanting against federal overreach. Police formed lines, separating crowds from entrances where vans carried detainees in and out. For many demonstrators, this was not just about immigration policy. It was about defending the idea that communities could choose their own rules without being forced to follow Washington's commands. While protesters raised their voices, another set of voices emerged in support of the federal crackdown. Families of victims who had been harmed by undocumented migrants told their stories at press conferences organized by administration allies. They described crimes that shook their communities and argued that detainers could have prevented them. These testimonies became powerful tools for the administration, reinforcing its claim that sanctuary laws endangered lives. The contrast was stark. One side demanded protection of immigrants and local rights, while the other demanded justice for victims of crime. In courtrooms across the country, lawsuits began piling up. The Department of Justice moved to sue the non-compliant states, while California, New York, and Illinois filed countersuits to block funding cuts. Judges issued temporary restraining orders, keeping grants flowing while cases moved forward. Lawyers debated constitutional clauses, citing the 10th Amendment, the 4th Amendment, and prior Supreme Court rulings. Court calendars filled with hearings, each one another battle in the broader war over sanctuary policies. The fight was no longer theoretical. It was a grinding legal war. The confrontation became a defining political moment. Supporters of the administration framed the issue as a test of law and order, arguing that states were shielding criminals. Critics framed it as a fight for civil rights, warning that unchecked federal power threatened democracy itself. On talk shows and in town halls, Americans debated fiercely. Some insisted that no state should block immigration enforcement, while others argued that federal agents were trampling constitutional protections. The divide reflected the broader polarization of the country, with immigration as its flashpoint. By the end of September, one thing was clear: this conflict would not be resolved quickly. The administration had drawn a line with threats of lawsuits and funding cuts. Sanctuary states had stood their ground, defending their laws and constitutional interpretations. Protests, lawsuits, and media coverage ensured the story remained in the spotlight. What began with letters from Todd Lyons had grown into a national showdown over power, rights, and the future of immigration enforcement. It was not only about holding individuals for 48 hours. It was about who truly held authority in America, Washington, or the states. This is the end of that story. Now tell me in the comments, what's your story? I'll read out the most interesting ones in the next video. Do not forget to hit a like button and subscribe. See you.